Thank you, Chair Buckley. My name is Antonio Ingram. I serve as a senior counsel with the NAACP Legal Defense Fund, and I'm here to oppose House Bill 3. You see, I'm concerned about the use of public funds to send Black children to private schools who are not required to follow federal civil rights laws. As you know, public schools receiving federal funding must adhere to Title VI of the Civil Rights Act of 1964, prohibiting discrimination on the basis of race, color, and national origin in programs and activities receiving federal financial assistance. Title VI provides an important obligation for schools to cultivate educational environments free from racial discrimination. Unfortunately, Title VI does not apply to private schools who do not receive federal funding. As a civil rights lawyer, I have represented Black students in Texas who have experienced severe racial discrimination at school. Fortunately, my Black clients attended public schools in Texas and could invoke Title VI. However, what if my Black clients had attended private schools in Texas using state funding under House Bill 3? Despite experiencing racial discrimination, my clients could not have invoked the protection of Title VI. I have deep concerns about the choice House Bill 3 gives Black families. Black families would have an impossible choice, I would argue: send their children to a private school without Title VI protection from racial discrimination, or send their children to now even more underfunded public schools. Please vote no on House Bill 3. Thank you.
Right. Thank you for your testimony. Mr. Liu.
Great. Good evening. My name is Alan Liu. I serve as a policy counsel at the NAACP Legal Defense Fund. I am also a resident of Texas and a father of a beautiful one-year-old now, who I hope will learn in well-resourced, diverse, and inclusive schools here in Texas. LDF strongly opposes House Bill 3 in part because it deepens racial segregation in Texas. 70 years after Brown versus Board of Education was decided, many of Texas's schools remain racially segregated. Private schools are mostly attended by white students who can afford it, and most Black Texans attend public schools. At the same time, a wide majority of Black and Latino public school students are economically disadvantaged, while white students are not. So House Bill 3's voucher program, which will siphon public money from public schools, will disparately harm Black Latino students in the schools that serve them. These dynamics, coupled with the fact that poor and Latino students are less likely to apply and even be accepted into private schools, will have the effect of concentrating Black and Latino students in public schools and wealthy white students in private schools. And as a result, public schools will have less experienced teachers, less well-paid teachers, less teachers who teach their expertise of study, more teacher turnover, less textbooks for class and books in libraries, less heating in the winter, less cooling in the summer, less extracurriculars and sports programs, a lack of advanced curriculum, including AP courses and language programs, less parent-driven fundraising, less pipeline and connections to college. For Black and Latino students, it will mean more discipline and police in schools. So LDF strongly urges an unfavorable vote for House Bill 3 because it'll worsen racial segregation in Texas and disparately harm Black and Latino students in schools. And I welcome questions on the history of segregation in the United States and in Texas to sort of demonstrate the history of public school choice and the connection to this bill here. Thank you.
All right. Thank you very much for your testimony. Members, any questions? All right. Thank you very much for your testimony. Representative Leo Wilson.
I'm reading Title VI right now. It does apply to private schools. Why do you say it does not?
They have to be the recipient of federal funding.
Okay.
So for private schools, the recipient of federal funding, but it is my understanding that this bill would apply to all private schools, not only ones who are receiving federal funding.
Okay. So you're saying that it says it's under the status of the 5013C, that's the federal tax exemption, that's what you're saying? That
501c3 status does not equal being a recipient of federal funding based on Title VI.
Right, okay,
So you can be a 501c3 and not be a recipient of federal funding, and therefore not be obligated to comply with Title VI.
it says even if the school is religiously affiliated and if it claims a tax exempt status, it applies.
That is not my understanding of Title VI.
Okay, well, that's what it says.
What are you reading?
I'm reading the interpretation of Federal District Judge Richard Bennett's decision.
As you know, district court judges do not set precedent. That's usually circuit and appellate judges.
Okay, well, that's how he interpreted it, so,
And that's not binding on the Fifth Circuit, which is where we currently sit.
okay.
All right.
Thank you.
Members, any more questions? All right. Thank you very much for your testimony.
Thanks.